attorney Michael Watts. Thank you so much for joining us.
My pleasure, Hank.
Mike, let the audience know the nature of your practice.
Sure. I represent a variety of businesses and individuals being sued in civil lawsuits over money. So anyone from individuals to insurance companies to hospitals to physicians.
Once you've been assigned a case to defend, Michael, if you and opposing counsel cannot settle the case among yourselves, is the matter generally scheduled for mediation before a case is tried?
Virtually always. Almost every jurisdiction in Colorado requires civil lawsuits to go through mediation before we can ever get to the courthouse steps for trial. That includes Colorado Springs and Pueblo.
In an average year, how many mediations would you say you participate in, Michael?
Probably 15 to 20 mediations every year.
And what jurisdictions in Colorado does that cover?
I've handled cases in every jurisdiction in Colorado. The mediations don't necessarily take place where the case has been filed, but I've mediated or done some sort of alternative dispute resolution in every jurisdiction in Colorado.
With that mediation experience, Michael, do you think that the mediator can make a difference on whether a case settles or not?
Absolutely.
Why do you say that?
The more involved the mediator is, the more invested they seem in the case, at least in terms of their interest and their understanding of the issues, the more receptive the parties are going to be to what the mediator has to say. And from my perspective, representing the folks being sued, and particularly being involved with the insurance companies that have money on the side of the case of the defendant, it helps a lot of time to have a mediator who's expressed an interest and an understanding in the issues and doesn't just go from room to room shuttling numbers, but actually has a grasp on the strengths and the weaknesses that both parties are facing.
Since your client is typically an insurance company, an entity that the general public would view as having very deep pockets and very tight and wanting to share any of it, what has been your experience in getting your client's top dollar settlement figure on the table?
Very good if we have the information we need. And the earlier in the process that the other side provides us all the pertinent records, any pertinent bills, the better we have going into mediation to actually get the case resolved.
So if a plaintiff has his case together early on, from your experience, does your client produce any significantly different number to settle at that point than it would on the courthouse steps before trial?
Typically, no. If we have the information we need early, we can get the case teed up for mediation relatively early. And from the get-go, the client knows the cost of defending the case through trial, and that cost typically is not going to change the closer we get to trial. So the sooner we have the information, I think the sooner we can get the top dollar on the table out of mediation.